And I wanted to provide an overview of regulatory agency lobbying. What is it? How is it different from legislative advocacy that most of us are familiar with? From my perspective, both forms of lobbying, legislative or regulatory, are quite similar. In other words, legislative advocacy, legislative lobbying, is lobbying for or against legislation in the legislative branch of state government. Regulatory advocacy is lobbying for or against regulations in the executive branch of state government. Now, obviously, that's a simplistic view, and there are quite a number of differences, particularly in the regulatory process versus the legislative process for adopting legislation versus adopting regulations. But in many regards, the role of the lobbyist is similar. For example, I think a good lobbyist will have subject matter expertise regarding the regulations that they're working on. He or she will have important contacts and working relationships with key executive branch agency personnel. And obviously, the regulatory lobbyist will hopefully possess good advocacy skills, both in writing and orally. So, why is regulatory agency advocacy important to lobbyists? I think the easiest way to look at it is that just because a statute has been enacted into law doesn't mean the battle is necessarily over. In other words, there's another opportunity to perhaps limit or expand your success. And this occurs in the regulatory environment. Moreover, even if you were successful in getting the underlying statute enacted, it doesn't mean that you don't have to worry about, for example, the opposition to your statute making efforts to try to rein in the reach of that statute through the rulemaking process. So, to set the stage for understanding regulatory agency lobbying, you need to be aware that California has about 230 agencies, departments, boards, and commissions that make public policy through their statutory authority to adopt regulations for them to make law. According to the Office of Administrative Law, OAL, which has the authority to review all of these regular and emergency rulemaking projects, there are between 7 and 800 regulations adopted each year by these state agencies and departments. And just by way of background, these executive branch entities engage in both quasi judicial and quasi legislative activities. What's the difference between these two? Quasi judicial generally refers to the departments and agencies interpreting and enforcing the laws that are under their statutory jurisdiction. So they're kind of acting like the judicial branch, the interpreter, the enforcer. Quasi-legislative means the regulatory body is engaging in rulemaking by adopting regulations. So they're acting in a kind of legislative branch activities. Similar to the rules for the legislative process, California's regulatory process is a world of its own with its own set of rules and procedures. And just like in the legislative process, an effective regulatory advocate is going to know those rules and the players, of course, that are engaged in those procedures. So, studying the APA. So, those are the general rules that guide state agencies in their rulemaking activities. In California law, just like the federal government and the other 49 states, require these executive branch agencies to meet minimum procedural requirements that are established by the California Administrative Procedure Act, the APA. And the APA governs the adoption, amendment, or repeal of regulations unless the agency is expressly exempted by statute from following the APA. Now, generally speaking, the authority of these state agencies and departments is to adopt policies by engaging in rulemaking, and that's defined and perhaps even restricted by their authorizing statute. So statutes prescribe the agency's rulemaking authority, and it's an established principle of administrative law that agencies cannot exceed their legally prescribed authority to regulate. On the other hand, many statutes enacted by the legislature and the governor can confer broad powers to some of these agencies regarding matters that directly affect the general public. So some state departments that have broad grants of rulemaking authority include the DMV, the Air Resources Board, the Department of Fair Employment and Housing, now called the Civil Rights Department. There are a number of areas where regulatory advocates can attempt to influence the rulemaking process. And so that's why you want to understand the different nuances of the APA and the formal rulemaking process, as well as the role that's played by OAL, the Office of Administrative Law, because the APA provides a number of opportunities for interested parties to not only be informed, be noticed by what rulemaking is going to occur, but also the ability to participate in those rulemaking activities of these state agencies and departments. The first rule for the regulatory advocate, I think, is to stay apprised of rulemaking authority. And so agencies and departments have to annually adopt a rulemaking calendar that's published on their website, and it's provided to interested parties by way of mailing lists, mainly electronic today, of their proposed rulemaking activities. So if you or your client plan on submitting written or oral comments at a rulemaking, it's important that that presentation be effective so that you're successful. Effective comments are based on an understanding of the statutes as well as the factual material that the agency is relying on when it proposes that rulemaking activity. And you, of course, want to understand what the proposed rulemaking is going to do to your client or your industry or whomever you are representing. And of course, you want to be well aware of the 6 standards of review that is utilized by the Office of Administrative Law when it reviews a regulation once the rulemaking process has been completed by the agency or departments. Regulatory lobbyists also need to be aware of potential avenues for impacting rulemaking activities. For example, if it's a line agency, can the governor weigh in and influence the state agency activity? The legislature can influence state agency when they grant the authority to adopt regulations. They can also exercise oversight authority during the annual budget process. The legislature can naturally exert some influence because they provide funding to those state agencies and departments. They can also adopt what's called budget control language that directs agency activities and the use of monies appropriated there. The legislature can hold informational or oversight hearings to review agency actions. In addition, the legislature has several control agencies, such as the state auditor, the legislative analyst. They can review or even investigate an agency's activities to regulate or implement a law. The legislature can also ask the OAL, the Office of Administrative Law, to review regulations. And these agencies can be pressured by a number of informal or behind the scenes efforts that are made by legislators, legislative committees, even legislative leadership. There are also ways for interest groups to influence state agencies, usually to participate in the rulemaking activities, both submitting written comments as well as oral comments at a public hearing. Groups can perhaps lobby the governor's office, maybe try to get into the legislative arena and try to influence rulemaking activities. And ultimately, if an interest group or an individual is unhappy with an adopted regulation, they can initiate litigation to challenge the validity of that agency's rulemaking activities. I think interest groups could even instigate media attention, some press coverage regarding a state agency's actions or even inactions. And of course, regulatory lobbyists may try to influence the agency that is responsible for overseeing the department that might be developing a regulation. They may instigate actions within the legislative branch to either express concerns or maybe put some pressure on those agencies. And then one last item of interest is that there are two additional ways for interested parties to challenge an agency rulemaking. First is that any interested party may petition an agency requesting adoption, amendment, or repeal of a regulation. And here, with that written petition, the agency or department has 30 days to respond. The other way, as I briefly mentioned before, is that any interested person can obtain a judicial declaration regarding the validity of any regulation, or even to pursue an order of repeal. And they do so by bringing a civil action for declaratory relief in Superior Court. And the right to judicial determination, by the way, is not affected by your participation or lack of participation in filing a petition with the state agency, for example, of their review of their rulemaking activities.